Mr. President, the judges Donald Trump appoints to lifetime positions on our federal court will be a lasting legacy, and he is determined to do whatever it takes to place as many nominees with an ideologically driven agenda on the bench as possible. Today, the Senate is debating whether to give Gregory Katsas a lifetime appointment to serve on the United States Court of Appeals for the D.C. Circuit. Throughout his career, including as Deputy White House Counsel under Donald Trump and a senior official in the Justice Department under George W. Bush, Mr. Katsas has demonstrated a profound conservative bias inappropriate for service on the country's second most important court. As Deputy White House Counsel, Mr. Katsas has been deeply involved in crafting the legal justification for many of the Trump administration's most controversial policies. He also played a key role in deciding which court cases the administration would support or oppose and recommending candidates for various executive and judicial appointments. The legal issues he's managed, the advice he's given, and the appointments he's recommended raise serious concerns about whether he should receive a lifetime appointment to the federal bench. In the early days of the administration, Mr. Katsas participated in crafting the legal justification for the president's Muslim ban, a policy at odds with the Constitution and our values as a nation. Mr. Katsas has also been involved in orchestrating the administration's opposition to LGBTQ rights in the courts. In particular, he openly admits his role in the Justice Department's decision to argue in a case before the Second Circuit that Title VII of the Civil Rights Act of 1964 does not prohibit discrimination on the basis of sexual orientation. This position is inconsistent with the Equal Employment Opportunity Commission's 2015 guidance and with a recent en banc decision from the Seventh Circuit Court of Appeals. During his confirmation hearing, Mr. Katsas testified he was involved in the administration's decision to file an amicus brief in the Supreme Court case of Masterpiece Cake Shop versus Civil Rights Commission. He thus supports the position that a private business should be able to refuse to sell a wedding cake to a gay couple. By elevating a corporation's religious views over the rights of their customers, Mr. Katsas and the Trump administration argue that businesses should be able to say their work is an expression of their religious beliefs. This would allow them to discriminate against certain customers and turn our system of anti-discrimination protections and public accommodations on its head. These actions and positions should disqualify Mr. Katsas from serving on the D.C. Circuit. But there's more. We can also trace his record of pushing a partisan, ideological agenda during his time in the Bush Justice Department. In Hamdan versus Rumsfeld, Mr. Katsas argued that military commissions the Bush administration established after 9/11 were legal and consistent with the Uniform Code of Military Justice and the Geneva Conventions. In Boumediene versus Bush, Mr. Katsas also argued that people deemed enemy combatants and detained at Guantanamo could not challenge their retention on habeas corpus grounds. The Supreme Court repudiated these arguments in their landmark decisions in both cases. Mr. Katsas was also the public face of the Bush administration's opposition to the Native Hawaiian Government Reorganization Act, also known as the Akaka Bill. As the principal deputy associate attorney general in the Bush administration, Mr. Katsas testified in Congress that the Akaka Bill was unconstitutional. He went so far as to say it would, quote, create a race-based government offensive to our nation's commitment to equal justice and the elimination of racial distinctions in law, end quote. What was really offensive was that his testimony was legally wrong and insulting to Native people, the Native Hawaiians. In rebuttal, A bipartisan trio of highly respected former DOJ officials said in written testimony that Mr. Katsas failed to provide a credible and coherent legal argument against the Akaka bill. They argued that his testimony presented, and quoting them, quote, a caricatured view of the text of the bill and the governing law and should not be considered an authoritative guide for resolving legal disputes in this area, end quote. I agree. The Akaka bill did not confer status to a group of people based on race and ancestry. It did so by virtue of residency and sovereignty. With no grounding in fact or law, Mr. Katsas advocated treating Native Hawaiians differently from other indigenous peoples. Mr. Katsas's position on Native Hawaiian rights is of particular concern at a time when the D.C. Circuit could hear legal challenges to a 2016 Interior Department rule through which the Native Hawaiian community could reestablish, and I know, reestablish a government-to-government relationship with the federal government. Mr. Katsas has a disturbing record of pushing a partisan, conservative agenda not based on sound law that has no place in the D.C. Circuit. We cannot simply ignore his record and decouple his past actions from the person responsible for them. Mr. Katsas has clear policy preferences that are red flags as to how he will decide cases should he be confirmed to this lifetime position. I urge my colleagues to oppose this nomination. Mr. President, I yield the floor.